Hi, Josh.
Hi, Amanda. What are we talking about today?
I thought we would talk about a new Supreme Court decision. For reference, we're doing this video in June of 2025. The Supreme Court has been busy, and just recently they issued an opinion that may impact our employment law clients. What can you tell us?
The case is called Ames versus Ohio Department of Youth Services. It came down on June 5th, 2025. And it's a so-called reverse discrimination case. It involves a straight female employee who says that she was discriminated against because she's straight in favor of people who are LGBTQ. The case involves a claim of discrimination that lost in the district court at the first step of the McDonnell-Douglas framework. And the district court held that the employee, the plaintiff, could not state a prima facie case of discrimination under the relevant test in that circuit, the Sixth Circuit, because the Sixth Circuit requires majority group plaintiffs to show, in addition to a normal prima facie case, that there are, quote, background circumstances to support the suspicion that the defendant is that unusual employer who discriminates against the majority, end quote. Ms. Ames lost below, but she challenged that background circumstances rule, and the Supreme Court, in a unanimous decision, said the background circumstances rule is not consistent with Title VII. The Title VII analysis, the McDonnell-Douglas test for whether an employee plaintiff can get by summary judgment, can survive summary judgment, applies the same whether the plaintiff is a member of a minority group or a majority group. Discrimination is discrimination. It is based on the individual's characteristics and nothing about whether they are a member of a majority or a minority group. Now, it's important to note two things here. One, in the Second Circuit where we sit, that's Connecticut, New York, and Vermont, the background circumstances rule wasn't a rule. It was a rule in other circuits, but it doesn't change anything about the Second Circuit's analysis of discrimination cases or so-called reverse discrimination cases. The second thing to know is that there was a concurrence in the case from Justice Thomas, joined by Justice Gorsuch, that expressed real skepticism about the McDonnell-Douglas test overall and suggested that in the appropriate case, they would be willing to get rid of McDonnell-Douglas. Now, so far, that's only got two supporters, which means there's 7 justices who presumably don't support that approach. But it's something to keep in mind that every time the Supreme Court deals with a McDonnell-Douglas case, it is possible that they might reconsider whether the McDonnell-Douglas framework continues to apply to summary judgment. Remember, that's because the McDonnell-Douglas is a judge-made burden-shifting framework. It is not anywhere in the statute that was passed by Congress, or, for that matter, in the Connecticut statutes that were passed by the Connecticut General Assembly. So we'll continue to keep our eyes on that. For now, for Connecticut employment lawyers, Ames is interesting, but doesn't change anything about what we do on the ground.
Thank you so much for that analysis, Josh. Interesting how much employment law changes, and we appreciate you keeping us on our toes and keeping us informed. Thank you so much for watching, and we'll see you next time.